Section 6, Florida Laws and Commission Rules. The steps of the complaint process is a complaint's going to be filed with the DBPR. It's going to be investigated. There's going to be a probable cause panel put together for determination. If they determine that probable cause exists, there will be a formal complaint issued. There's a choice of informal or formal hearings being conducted. There are a few other choices too as well, not listed on here. The final order will be issued, and if they don't like it, the agent or the licensee doesn't like the outcome, they can always request a judicial review. Step 1, filing the complaint. The complaint is an alleged violation of law or rule, and it must be in writing on the Uniform Complaint Form of DBPR. To be considered legally sufficient, it would be a violation of a Florida statute, DBPR rule, or commission rule. The DBPR may investigate anonymous complaints or one made by a confidential informer if the complaint is in writing and legally sufficient, the alleged violation is substantial, and the DBPR has reason to believe the alleged violations are true. Step 2 is the investigation. The complainant is the person who files the complaint. A copy of the complaint is sent to the licensee, the subject of the investigation. The licensee may submit a written response, and a copy is sent to the appropriate regional investigative office of the DBPR. The DBPR conducts an investigation. They can administer oaths and take depositions, examine respondents, witnesses, and complaints. They may issue subpoenas and conduct audits of escrow accounts. The commission issues an investigative report, and they submit the report to the probable cause panel. If the investigation reveals that the public is endangered, the DBPR or the commission may not allow the licensee to continue to work during the disciplinary process. The DBPR secretary can issue an emergency summary order, promptly followed by a formal suspension or revocation proceeding. Step 4 is the formal complaint. Formal administrative complaint. If probable cause exists, the DBPR is going to file a formal complaint. It outlines the charges against the respondent, and the licensee is sent an election of rights. In the election of rights, they are instructed that they can choose not to dispute the allegations and request an informal hearing, dispute the allegations and request a formal hearing, or not dispute the allegations and waive the right to be heard. The licensee respondent can also choose to meet up with a DRE attorney prior to a hearing to discuss a settlement. This is called a settlement stipulation. Stipulation is an agreement as to the facts of the case and the penalty reached. Stipulation must be approved by the commission. So what they're saying there, I want to make sure you catch this. The attorneys can all agree on it, the respondent and everybody, but FREC, the commission members, have the final say whether they're going to accept it or not. Voluntary relinquishment for permanent revocation. A licensee may choose to avoid a disciplinary hearing and relinquish the license in lieu of discipline. This permanently puts the licensee out of the real estate business. Step 5 is when the case is presented in a hearing. Informal hearing means there's no disputed facts. The licensee given at least 14 days notice. The licensee presents the case to the commission at a commission meeting, and the commission, with the probable cause panel excluded, decides the case and imposes the penalty. Formal hearing. Licensee may request a formal hearing. Formal hearing is required if the facts are disputed. Formal hearings are conducted under FS 120. An administrative law judge selected by the Division of Administrative Hearings. They may issue subpoenas. They're going to recommend order findings, conclusion, and they're going to recommend the penalty. Step 6, the Commission issues the final order, final decision as to innocence or guilt and the penalty. Probable cause members are excluded. Commission considers the law judge's report and recommended order and filed exceptions. Step 7 is the right to appeal. 30 days to file the appeal. It does not stop the enforcement of the final order. In order to continue to work, the licensee may request a stay of enforcement from an appellate court. The court will then issue a writ of supersedeas, which stops enforcement pending the outcome of the appeal. There are 3 types of penalties for violation of real estate law: administrative, civil, and criminal. The Commission is limited to issuing administrative penalties. They cannot issue incarceration, put somebody in jail, and they cannot order restitution to the injured party. Now, they can fine us as much as they want, but they cannot order us to pay the party restitution. Some administrative penalties include denial of an application or refusal to redo, letter of reprimand, notice of noncompliance, citation, probation, administrative fines up to $5,000 per count, suspension of license up to 10 years, and permanent revocation. Citations are issued by the DBPR or the DRE, not the Real Estate Commission, and this is for minor violations. The licensee has 30 days to accept or reject the alleged violation. If there's no action, the case is closed, or they may file a written objection within 30 days, and the penalties run from $100 to $500. A notice of noncompliance is issued for a first-time offense of a minor violation established by rule. It does not result in economic or physical harm to a person. The licensee has 15 days to take corrective action, and failure to timely comply with the notice of noncompliance results in a citation or other disciplinary proceedings. If a broker's license is suspended or revoked, the sales associates and broker associates licenses are automatically placed in involuntary inactive status. Sales associates and broker associates may become active again under a new employer. Civil penalties are enforced by the courts. An unlicensed person performs real estate services. A licensee commits fraud in a transaction to recover money paid to the licensee or to deny payment of a commission. Criminal penalties are issued by criminal courts. Imprisonment and fines, other than administrative fines, are obtained in court, and the DBPR must refer criminal actions to the state's Attorney's General Office. Third-degree felonies included misleading statement or false information on a DBPR license application, unlicensed activity, theft or reproduction of a license exam, $5,000 per count, and up to 5 years in jail. First-degree misdemeanor is failing to provide accurate and current rental information for a fee, with a penalty of a fine up to $1,000 and/or 1 year in jail. Criminal violation of 475 is a misdemeanor of the second degree with a fine of not more than $500 and imprisonment up to not more than 60 days. The Real Estate Recovery Fund is to reimburse consumers who have been financially injured by a licensee. It's available to those found by Florida court to have suffered monetary damages from the act committed by a licensee who held current and active license when the act was committed, was not the buyer, seller, landlord, or tenant, and acted solely as the licensee in a transaction. Claimant requirements include a filed civil suit and receiving a judgment against the licensee. They must secure a writ of execution. They must execute an affidavit stating the final judgment is not on appeal, and they cannot be the spouse of an offending licensee. The time limit to file a claim is within 2 years of the violation or discovery of the violation, but not more than 4 years after the violation. Now, maximum payments is up to $50,000 per transaction and $150,000 per licensee in multiple transactions. The Real Estate Recovery Fund only covers compensatory damages and requires mandatory suspension until the fund is paid back plus interest. However, if a broker is sued for complying with an escrow disbursement order, the commission is authorized to reimburse the broker for the amount of the judgment up to $50,000. There will be no disciplinary action taken against the broker. The broker does not have to repay the fund. The broker must notify the commission of the court case and diligently defend it in court, the disputed actions concerning the transaction, and the commission may also reimburse brokers reasonable attorney's fees and court costs. When office inspections and audits are performed, the minimum office requirements are an office entrance sign, the licenses of the licensee, brokerage relationship disclosure, and if there's an escrow account, it will be audited. You will need the reconciliation statements and the broker's trust liability. This concludes Day 2.